other states where, as the employee, I have to prove that you misclassified me. Now, in Wisconsin, you have to prove that they were properly classified. This is a huge issue, and you guys should really be paying attention to that. How many of you give your coaches that little piece of paper to sign that says you're an independent contractor? Yeah, a couple of you, right? That means nothing, really. Okay? Just know that. Right? So, if you are 1099 your employees, you should have them sign that, although at the end of the day it means nothing. What I do say is that they're like those nice little waivers that we give. If I die, if I break my leg, whatever, I promise not to sue the volleyball club. Those mean nothing, as we know, because you can't waive negligence ever, but they're a deterrent, right? So it doesn't mean that you can't say, well, you signed this agreement, right? And half the time they go, okay, yeah, and then they don't go talk to a lawyer. So if you're going to not heed my advice, you should probably at least have them sign a document that says you're an independent contractor. That way maybe you can deter some sort of issue. But they really mean nothing in the law. Now, we'll get to it a little bit later. Sometimes if the factors that the IRS looks at are quite even, then maybe that agreement has a little bit of an effect, but 9 times out of 10 it doesn't. So, which one's right for my club? Each different issue, depending on who controls that issue, the Department of Labor, the IRS, if it's a state issue, has their own variation of the test. But what's kind of the central theme and the common analysis for every one of those tests is called the right to control test. Okay, this is really important. And basically what it comes down to is how much do you control that individual? The more control you assert over them, the more likely they are an employee and not an independent contractor. Okay? Now, this is where when I advise clubs, it's really helpful that I have the coaching and directing experience, right? Because you go to a normal lawyer, and half the time they don't know the proper questions to ask because they've never been in that gym, or they've never directed a club. So when clients come to me, I know what's really going on behind the scenes, right? And so I can ask the proper questions to make that kind of analysis and identification a little bit easier. And the IRS is picking up on what's going on, right? And when the coaches that are disgruntled are calling and saying, if they know what they're talking about, right, they're throwing in these factors that go to how much you control them. This is the IRS test. In the law, when you get things like this, they're either, you have to balance all these things and not one of them is determinative, or they become elements, right, which we'll talk about later with regard to some other issues, where you have to meet every single one. This is a balancing test for the IRS purposes. Okay, so they look at each one of these factors and they make a determination based on kind of the global overarching theme that you guys are implementing at your club. And we'll talk about each one of these in detail. The first one really comes down to that whole control thing, the instructions that the business gives the worker, right? So typically, independent contractors can do whatever they want as long as they get the job done and however they want it. Right, employees, though, however, are subject to control, right? The business gives them instructions on how to complete their job. The IRS talks about, do you tell the worker when and where to do the work? Do you tell them what equipment or tools to use and provide them? Do you hire their own assistants or individuals to help them with that work? Do you tell them what work must be performed by a specified individual? What order or sequence to follow? Right? The IRS says even if no instructions are given, sufficient behavioral control may exist if the employer has the right to control how the work results are achieved. The key consideration is whether the business has retained the right to control the details of a worker's performance or given up that right. So what does this mean for the club volleyball world, right? What I see a lot of times, do you set the practice times, the tournament schedule? Do you set the place where all of those things are going to occur? As a coach, do I have the right to come in and say, BJ, I only want to practice Wednesdays from 5 to 7, and I want to do it at this gym. I don't live here, so I don't know where that would be, but I want to do it at that gym over there. Usually not, right? Usually you guys, as the directors or owners or whatever, are telling them when they have to be there, what tournaments they're going to compete in, and where it's going to take place. Does the club provide the equipment for the coach? Yes, right? Like, I don't bring my own balls, I don't buy my own balls, I don't bring my own ball cart, I don't bring my own net. You guys provide all of that, right? Sometimes you guys provide my outfit, right? My jackets, my coaching shirts, my shorts, my shoes, whatever it is. Does the club mandate what the coach has to wear, right? To either practices or tournaments. So everywhere I've coached, I've been told I have to wear club gear to practice, or at minimum to that tournament, right? Now, I may have the option to pick between what shoes I want, or what pair of yoga pants I want to wear to the tournament. But everywhere I've coached, I've had to wear at least some sort of club identification, t-shirt, jacket, whatever. Does the club assign the team and the assistant coach? Right? So sometimes I get to pick my own team, kind of depends. Sometimes I come into a club and I'm told, you're given this team, it's already been picked for you, we already have tryouts. Sometimes I get to pick my own assistant, sometimes I come in and I'm told, this is your assistant, this is who you're going to have. Right? Does the club have some sort of rules, policies, procedures that the coach must adhere to? This is usually the biggest thing that obviously we see. So a lot of your clubs are going to have a coach's handbook or some sort of coach's requirements, right? Coach must be impact certified, right? Coach must adhere to this behavioral policy, right? No substance abuse, obviously, for reasons. No social media, no texting the player. And what I get pushed back a lot of times from the clubs is, okay, well that's not really our requirement, that's a safe sport, USAP requirement, regional requirement, whatever, so it's not really my fault, right? Doesn't matter, okay? Does the club have specific additional responsibilities for the coach? I worked at clubs where I was told, when you're off, you have to scout, right? Or you have to take stats. Or you have to video, and then you have to go back and review that video with your team, film review. Whatever it is. Sometimes I've been told, I worked at a club once where we had to submit monthly reports on our players, right? Or goals, status updates on our goals, things like that. Coaches meetings, mandatory coaches meetings, all of that kind of stuff goes to this control factor. Does the club control? This is one that's becoming more of an issue, right? So what I see a lot of times is we get these bigger clubs, and granted I'm from Colorado, I don't really necessarily know all of you guys' clubs out here, but we're getting clubs that are starting to control the offensive systems, the defensive systems, the warm-ups, all of that kind of stuff, right? So in Colorado specifically, there's a club that says this is what you're going to run, this is how we're going to do it. In fact, there's one club that has a coaching director that really plans a universal practice for everybody, and as a coach you just go in and sit there, really. Some clubs say we only at the 13s age, we're going to teach everyone to play every single position, so we're not going to have a designated setter, right? Great, except you were telling that coach how they have to coach. Some clubs say we're only going to run a 6-2 because that's what I believe in, we're only going to run a 5-1, whatever it is. No rotational defense, okay? These are the things that are popping up more and more as far as these specific club volleyball. And these are the type of things most lawyers don't know what to ask because they don't know volleyball, right? So they don't know to ask if you're mandating certain defenses. There are clubs now that are saying, I'm not going to get into theories of like game-like versus blocked training and all of that kind of stuff, but there are clubs now that are saying you can't 2-person pepper for warm-up. You've got to do, 3-person or whatever it is. So this is what I think is becoming more of an issue in this context. Training philosophies. Again, do you not allow blocked training? Are you like a grill? I don't know if you guys even know what I'm talking about, but are you more of a person that everything has to be game-like? Does the club control the manner of communication with the parents and athletes, social media, or mandate certain behavior while traveling? So you guys send coaches off a lot to qualifiers, right? Do you have a certain behavior that they have to adhere to? Do they have curfews? Do they have a certain communication policy? Whenever you're emailing parents, you have to CC, you know, the club director. Whenever you're, you can't text kids individually alone. Whatever that is, the more rules that you guys are putting onto them, the more likely they're employees and not independent contractors. Does the club control the coach's decision making by requiring them to implement a certain consequence on an athlete? We see this a lot too. So the club will have, you know, if you miss practice, this is the consequence. If you're late, this is the consequence. If the kid, I don't know, shows up to a tournament late, they can't play that first set, whatever it is. The more autonomy we're starting to take away from the coaches and their ability to make their own decisions. Bottom line, the more autonomy you provide your coach, the less likely they are to be employees, okay? This is probably the thing that the IRS and most other governing agencies that use some sort of form of the right to control test looks at the most, okay? And what I found in representing a youth sports organization, 9 times out of 10, this is weighing in favor of the employee status because we're starting to become more and more involved, excuse me, and taking away that decision making from the coach. Second factor, trading the business gives the worker. Again, this is where I get some pushback because they say, well, it's not my fault, right? I have to go by what USAV says, right? But we're requiring them to be impact certified. Safe sport training. Some clubs require CPR. Some regions, some clubs themselves require officials and scorekeeping certifications. I don't know about here in the Badger region, but in the Rocky Mountain region, every coach has to be a certified official because we have to ref our own tournaments half the time. Do you require mandatory coaches trainings? Right? So a lot of times clubs are starting to say, right before the season, everyone's got to come in here and we're going to go through whatever, right? Or we're going to have coaches meetings where we're going to talk about this is our philosophy, this is what we're adhering to. Some clubs have this like mentorship master coach program, right? Where there's somebody walking around, watching your practice, coming up afterwards, or maybe weekly or monthly or whatever, and talking about what they're seeing going on and how you can be better. Do you have a director of coaching? A lot of times that person kind of does the same thing. Sometimes they go in and they, again, like one club I work with, they provide the training schedule and what you're going to do. Do you have a mandatory coaches meeting, again, where you discuss systemic club and coaching issues and how you're going to address them? Typically, this factor weighs in favor of employee status because we're requiring, at a minimum, that coaches be impact certified. Safe sport, I think, is required now at this point. The extent to which the worker has unreimbursed expenses. This typically goes either way when I look at it because some clubs pay up front for their coaches to travel. Some clubs, the coaches pay up front and they reimburse them. Sometimes it's just up to the coach, right? 9 times out of 10, you guys are paying for qualifier travel, that type of thing. But if I drive to a tournament that's an hour and a half away, are you reimbursing me for the gas or is it just on me? I don't know. I've seen that go both ways a lot of times. Do you reimburse any expenses related to continuing education? Some clubs, if I want to take a CAP course, some clubs reimburse you for that. Some clubs pay up front. Some clubs say, you're on your own, I don't care, right? HP clinics down in the Springs. Some clubs are finding or sending their coaches there. I do have one club that I worked with that has implemented a policy of, if you want to take a CAP course, we will reimburse you X amount per year that you're with us, something like that. ABCA convention. Some clubs send their coaches to that and pay for them. A lot of clubs just say you're kind of on your own because we can't afford that, right? So that's usually why it goes either way. The other really big one is the region and USAV membership. So 9 times out of 10, I'm finding the clubs pay that for the coaches, either by way of doing it themselves, or coaches go and put it in and then we reimburse them for that. Impact fee. Specific to this region, I don't know how you guys handle it, but where I've seen it a lot is the clubs are paying the impact fee. Right. Any referee or scorekeeping clinic, do you guys pay for that, or does the coach pay it? Depending on how you handle these things, it could go either way. This is one that I've seen not kind of a clear consensus as to how clubs are doing this. The extent of the worker's investment. The more investment the worker has, the more likely they are an independent contractor. Okay? Typically, in this context, it goes in favor of employee status. Why? Because as a coach, I really don't have that much investment. Right? I've got some training, I coached for, a bunch of years, but I don't invest in my own balls. I don't invest in my own ball cart, right? The most I really invest in is maybe, personally, I'm PAP 2 certified. That was my own investment. But other than that, I don't really have much investment in it. A significant investment is not necessary for independent contractor status. However, independent contractors often have more significant investment in tools, facilities that they use, that type of thing. 9 times out of 10, I'm seeing this go in favor of employee status. The extent to which the worker makes services available to the relevant market. This is really, really important in this context. Independent contractors are really able 9 times out of 10 to work for whomever they want, right? As long as they get their job done and they're meeting the terms of the contract. The majority of the time in the volleyball world, we are not allowing coaches to work for other clubs at the same time they're working for ours. And it makes sense, right? I mean, it's common sense as to why that happens. However, this goes so much in favor of employee status in every context that I've seen it. Now, a lot of times I'll hear, well, the region doesn't allow us to work for more than one club. I don't think that's the case in this region, I think after talking to BJ, but in the Rocky Mountain region it is. We cannot affiliate or associate with another single club, period. Do you restrict the right of do you make coaches sign a non-compete agreement? I've had clubs in Florida that I'm working with right now that this has become an issue. I don't know if you guys do that here, but if you're restricting the right of the individual to work for somebody else even after they've ended their relationship with you, big problem. Okay. Private lessons. Do you allow, as a coach, to go to another competing gym or club and give private lessons in their facility? I don't know. Really, really big issue though, because we don't allow coaches to coach for other clubs while they're coaching for us, right? And obviously we can't allow them to be rostered in AES and all that kind of stuff with other clubs, but if they want to go just hang out at BJ's practice and help, right, are they allowed to? Typically not, for obvious reasons. How the business pays the worker. This really has little, if anything, to do with the determination. However, again, in close cases, it could go in favor of independent contractor. How do you guys pay your coaches? Hourly? Do you pay them set amount per season, divided up by however many months? Do you give them incentive plans? You know, if you qualify for nationals, you'll get X amount more. Everyone does this differently. I haven't really found one typical consensus or way that they've done it, but just keep in mind that it may have something to do with the determination. The extent to which a worker can realize a profit or loss. This is big too. As a coach, I have no bearing on the club's profit or loss, right? Profit or loss means the amount that I invested and the amount that is returned. I invest nothing, right? Now, obviously, I may be able to help the club if I'm a really great coach and I keep getting people to come back, but I don't realize that investment. You guys get it. Typically, this goes in favor of employee status because I've never seen and really can't think of any situation where the clubs provide some sort of structure that allows me as a coach to make a profit or a loss. Oh, I forgot to tell you guys, if at any point you guys have a question, feel free to just raise your hand and ask, by the way. I sometimes take for granted that I know what I'm talking about up here in the legal world, and that sometimes maybe it's not conveyed appropriately or properly to you guys. So if at any point I'm not making any sense, just stop me and ask. Written contracts describing the relationship the parties intended to create. That's a nice little document we talked about, putting your coaches under independent contractor. Again, the IRS states it's probably the least important of the criteria, since what really matters is the nature of the underlying work relationship. However, in close cases, it could weigh in favor of independent contractor status, depending, I mean, like really close cases. And I have only in one situation ever read about or heard this actually making a difference. Whether the business provides the worker with employee-type benefits. Obviously, the majority of the time, this goes towards independent contractor status in our world. You're not providing any sort of pension plan or insurance, anything like that. The only thing that I've ever seen become an issue is, obviously, you're paying X amount unless you pay your employees hourly, or your coaches hourly, excuse me. They really are getting sick or vacation pay, right? Because it doesn't matter if they come in or they call in to practice or a tournament or whatever, they're still going to get paid whatever you agreed to pay them. So that has been construed often as considered vacation or sick pay. But otherwise, this is usually in favor of independent contractor status for our world. The permanency of the relationship. Depending on what your guys' employee, coaches, independent contractor, whatever contract says, usually this goes in favor of independent contractor status in our world, just because if your contract is well written, it says something to the effect of this is for the 2016-2017 season. At that point, the relationship terminates, and then we have the right to end the relationship or bring you back if we like you. If you don't have something that says that, you need to put it in whatever documents you have with your coaches. This is pretty critical. The extent to which services performed by the worker are a key aspect of the regular business or company. I mean, come on, obviously coaching is a pretty key aspect to the business. This really, the example that I could give is if one of your coaches does website design, something like that for you. Obviously, that's not integral to your business. So with regard to their website status, website designer status, they're probably an independent contractor. And then there becomes an apportionment issue at some point later down the line that you guys should not even worry about. But because our business is volleyball and providing volleyball training, education, a club for these kids to play in, and the coaches are doing that, it's very, very obvious that this is weighing in favor of employee status. Oh no, right? Like we're just totally sitting here going, Jesus Christ, I've been doing this all wrong this entire time. What in the world am I going to do? What can happen? I screwed this up, right? What can happen and how can I fix it though? First of all, relax. It's going to be okay. You're not in trouble. Okay, but penalties. So, the IRS differentiates between willful conduct in this classification versus I'm just stupid and I didn't talk to anybody and I didn't mean to, right? Unintentional. So for unintentional, it's $50 for each W-2 that the employer failed to file because of the misclassification. In addition, there are penalties of 1.5% of the wages plus 40% of the FICA taxes that were not withheld from the employee and 100% of the matching FICA taxes that the employer should have paid. Interest also accrues from the time that they should have been paid. A failure to pay tax penalty equal to 0.5% of the unpaid tax liability for each month, up to 25% of the total tax liability. This is serious stuff, guys. Like really serious stuff. And that's why I can't impress upon you enough that this is something that you really should be paying attention to, because it's becoming a bigger issue where the IRS is starting to audit youth sports organizations because they know we've been screwing this up for a really long time. Clubs have been in business for 10 years. We've got a lot of problems, right? Intentional. All of that we just talked about, plus increased penalties, criminal penalties potentially. I don't think that there are really ever instances that not that I'm aware of, that a youth sports organization has been found to be intentionally misclassifying their coaches. However, now that you guys are aware of the issue, right? Like, gotta kind of look into it a little bit more. Now, there are ways that you could kind of help yourself out with this, right? Go to a lawyer, okay? Get some sort of advisory opinion that says, based on reviewing everything that you've provided, here's my opinion on it, right? Hopefully it's helpful to you. I'm going to guess that they know what they're talking about the majority of the times your coaches are employees. But if they say independent contractor, great. Then you can say, no, I relied upon that opinion. And therefore it wasn't intentional, it was unintentional. Right? So you've got ways around it. In Colorado, we have this nice thing where you can pay, I don't know if you have it in Wisconsin, $100 to the Department of Labor, and they'll issue an advisory opinion. Not binding, but it helps to negate the willful argument. So what do you do now? Right? Oh my God, I may have screwed this up. I don't want penalties. There's a club, again, that was fined almost $400,000 for screwing this up. But there is a solution, okay? First of all, don't panic. It's all gonna be okay. We can fix it, right? You need to go talk to an attorney if you are really concerned about the issue, which I think you should be. If upon further review your coaches seem to still be employees, you need to change the classification as soon as possible, okay? The IRS has this really nice program that they've implemented, and it's largely in result to youth sports organizations that have great intentions, right? We all want to provide a really, really great experience for kids. There's not a lot of money in this, right? We don't make a lot of money from coaching. We all have really good intentions, and we're usually lay people that are setting this up. And so the IRS really doesn't want to put these type of situations out of business, so they kind of created this relief program for instances of this. And it's called a voluntary classification settlement program, okay? And you can go back and you can reclassify your workers as employees for future tax periods, but you do get a tiny little penalty, right? We'll pay 10% of the amount of employment taxes that would have been paid due upon compensation to the workers being reclassified for the most recent year at a reduced rate. However, the really important and great thing about this is that you get a complete waiver, grandfather, bar, whatever you want to call it, to every single penalty that you may have owed because of your past misclassification. So if you've been in business for 5 years, and you've probably been misclassifying coaches for 5 years, right, you only get hit with the current year's penalties at a very reduced rate, and everything that comes prior to that has been waived, essentially, by the IRS. It's a really, really good program, especially if you've been in business for a while. Oh, question, yes?
I don't really have a question. I just want to point out to you that, and I know, how many coaches in here have been running a club since 2011 or 2012? That's a question, okay? The region actually brought in an accountant, James Wright, with the accounting firm of RWB, to talk to all of us about the changes in the IRS and state of Wisconsin employee classifications. Probably everybody in here who's had a club that long should be aware that we did receive training at that point in time. And the IRS or the state of Wisconsin will go back and, because they're going to check what the region did, they're going to ask if you've had education, whatever the case may be. You have to be aware that they can go back to that period of time and look at how you've been classifying employees, because that's when the laws change. prior to that time, the state of Wisconsin, and they reclassed that the definition of employees was different. And at that point, when they brought in the CPA to give us a presentation, we were all told that we all fell under, for the most part, the definition of having W-2 employees. So for new club directors, you know, less of an issue, but the clubs that have been in business since that period of time, they're going to go back. And they can fine you and penalize you for this entire period of time.
Right, and it really goes to that intentional or unintentional,
Yes,
right? Because
and Wisconsin, state of Wisconsin also has this voluntary classification settlement that you can do, just so everyone knows. They started that as well.
awesome, right? Because at this point, they're going to say, well, you were put on notice, okay, and at that point you didn't heed that kind of advice, and so it may or may not be an intentional misclassification. They'll ask you, are you even aware of employee misclassification? At this point you are, and in 2011 you are, right? So again, there are ways to work around it, but this voluntary settlement is a really, really good option. And the majority of my clients that have, this has become an issue, this is the way that we've gone, right? Now we're gonna switch gears. Still has a little, does anybody have questions about that? Yes?
Is there like a checklist or anything you have of things you need to have to be okay if you get audited? Like I'm sure W-2s, you know, you apply with the WD and report it. Is there anything else that you have a checklist of what you need to be sure you have to be safe?
So I would say obviously the documents that you just talked about, there's not necessarily a checklist. What I would advise my clients personally is you need to have a very, very good written policies and procedures contract with your coaches. Depending on whichever way you want to go with this, independent contractor or employee. But a lot of times I see these policies and procedures, the coach must do this, the coach must do that, the coach must adhere to this and that policy, and if not, you know, then we have all of these options. But then you've signed this agreement that says you're an independent contractor.
Okay, well I guess, so with my club, you pay the employees, or you pay them as employees. So we do W-2s, we pay unemployment tax, we pay all that stuff. So we already have them classified as employees. So then
I think if you get audited for purposes of this, I think you're fine. Any other questions? Okay, so we're gonna kind of stick with this same theme, but you guys also might not like this second part of this presentation. Probably gonna upset you based on my understanding of talking with some of the region people and especially your commissioner here. We're gonna cry. It's gonna be sad. Okay. Workers' compensation insurance in Wisconsin. Who here has workers' compensation insurance on their coaches? Look around. Wait, keep those hands up. 1, 2, 3, 4, 5 people. 6. All right. Here's the deal. Workers' compensation insurance is required. Required. You can't get out of it. You have to carry it in Wisconsin. Okay? Apparently this is not widely known. Right? But a whole bunch of stuff up here that you can't really read. Every single club coach in the state is considered an employee for purposes of Wisconsin workers' compensation law. Okay? This sometimes is confusing to non-lawyers because they say, well, didn't you just talked about this IRS thing where there's like a couple of options? But here, Wisconsin has this beautiful little 9-part test. And you have to meet every single element of the test to be considered an independent contractor. If you do, and you are considered an independent contractor, you don't have to carry workers' compensation insurance. However, I would challenge you to find any situation in the club world where a coach would meet all 9 of these, what I'm about to show you, because there's no way, there's just realistically no way that a coach could ever be classified as an independent contractor for purposes of workers' compensation law in Wisconsin, right? Which means you have to carry it. You employ 3 or more full or part-time people, which you got yourself, and then you've got a coach and maybe an assistant coach. If you have more than one coach, you've got to do it. Or if you employ 1 full or part-time person to whom you've paid combined gross wages of $500 or more in any calendar quarter, which is probably every single person in this room. Anybody not meet either of those 2? No, it's impossible. You can't run a club. Okay, here's the 9-part test. Remember, you have to meet every single one of these. 8 out of 9 still makes them an employee. And I think maybe there's something included in your folder that has this, but number 1, the worker must maintain a separate business. What coach maintains a separate business? Okay. State of Wisconsin has said this is meant by showing that the worker maintains some space somewhere that resembles an office or facility, or chooses a place to perform the services. The individual also uses either materials or equipment that are their own. Anybody have a single coach that meets that? No, right? Automatically employees for purposes of this, and you have to carry workers' compensation insurance by law. Okay. Point 2, the worker must obtain a federal employer identification number or has filed business or self-employment income tax returns with the IRS based on the previous work year. That we can usually do. Obviously, coaches don't usually have their own employer identification number, but if they coached last year, they probably were misclassified at that point too, and filed their own self-employment taxes. But again, they didn't meet number 1, so it doesn't matter. Number 3, operate under specific contracts. Worker must be able to control their own work and set their own hours, according to the state of Wisconsin. Again, don't do it. Goes back to what we talked about in the beginning. Number 4, be responsible for operating expenses under their contract. Kind of depends. I mean, obviously, we talked about a little bit earlier. Maybe if I have to pay my own impact fee or my own officiating fee, region registration, that kind of thing, maybe. But we didn't meet number 1, so it doesn't matter. Number 5, be responsible for satisfactory performance of work under the contract. Usually, if you guys have a well-written contract, that requirement would be met, but it didn't matter. Number 6, be paid per contract per job by commission or by competitive bid. We could probably meet that the majority of times, but it doesn't matter. Number 7, be subject to profit or loss in performing the work under the contract, kind of like we talked about in the beginning. Number 8, have recurring business liabilities and obligations. The employer can satisfy this requirement by showing that the worker has proof of a cost of doing business which the worker would incur even during a period the worker was not performing. Can't beat that. How can you show me that as a coach, if I wasn't working for you, I would have expenses? Just as a coach that didn't have a job, right? We can't do that. Number 9. Be in a position to succeed or fail if the business expenses exceed the income. Can never meet this either, right? If the individual is guaranteed to receive the amount expected from the employer, which they are, usually, depending on how you pay them, I get paid X amount for the season to coach. The employer, without any possibility of loss, this requirement is not met. We can't do that, right? Because you're going to pay me, and there's never a possibility of loss, or why would I do it, right? Why would I coach? If you're going to pay me $5,000 for a season, and I have the potential to spend $6,000, like, what? Why? No, we never do that, right? So, nobody in this room, I guarantee you, can meet this test. And therefore, from a practical standpoint, every single one of you must require workers' compensation insurance. And this is regardless of your affiliation. It doesn't matter if USAV, AAU, JVA, any of that. Okay, this is not a USAV Badger region requirement. This is a Wisconsin law. Okay. And I lost my train of thought, sorry. What? Like what? What's going on here? Right? Really? Yes, this is really a thing, okay? And did anybody even know about this? One person? Got one person? 2 people? A couple of you? Yeah, right? The ones that actually raised their hand and said that they were carrying workers' compensation insurance. How'd you guys know about it?
My lawyer told me.
Your lawyer told you? What? We know what we're talking about.
Accountant and lawyer.
Accountant and lawyer. 2011? Yeah.
I'm gonna don't.
Look! Yeah, so like, you guys know I'm just not making this up, right? I have no like interest. I don't own an insurance company that I'm gonna pitch to you at the end. I have no interest in this. This really is a thing and it really is a law. Yes, really. Now, what happens, right? We all, everybody but those like 6 people have been screwing this up. Okay. What happens? You're subject to a penalty of double the insurance premiums that you should have been paying for the uninsured period, or $750, whichever is greater. Now, this isn't that bad, right? It's okay. We can fix this. You face closure of your business, including a suspension of all operations. This is what's really important. $750 we can live with. Closing my business, that's a huge issue. Really, the other really important thing is you're personally liable for any uninsured benefit claims for which your employees are eligible. So, as a coach, if I'm up on a box, which you may or may not should be doing, I don't know, and I fall off and I break my leg. And let's say I break my leg and then I go to the hospital and they do a million different tests and I have $50,000 in medical bills. The employer is now responsible because you guys did not carry the appropriate insurance. Or, I've never really seen this come up in a context of workers' compensation insurance. I've seen it come up in the context of third-party liability. This is kind of where my bread and butter is. What I do for a living besides represent youth sports organizations is I represent insurance carriers. I represent Allstate, Progressive, Geico, and I really do kind of have an expertise in liability and third party and first party. So where I have seen this come up before is with regard to that third party liability. And what does that mean? Anybody know what third party is? Okay, yeah. So if I hit BJ and it's my fault, I am now the third party for BJ and I owe him money. Okay, I'm a third party. So if I'm your employee for purposes of workers' compensation law, remember, there's a difference, and I'm driving to a tournament. There's now a theory out there that's called the respondent superior. You don't need to know what that means, but basically know that I'm an agent of your club because I'm an employee. And I hit BJ, just driving, and he's a pedestrian or he's in his car, I don't care what he's doing. And I hit him. And unfortunately, we're all really sad, BJ dies. Now, because I was in the context of working, I was going to a tournament, I'm no longer personally liable. Now, I may be liable criminally, right? They may take me to jail. But personal liability, I have Geico for my own insurance. Geico's not responsible. You're responsible as the employer. That's a really big deal. Now, in that same accident, I hit BJ dies, and I'm also really injured. And you guys are not carrying workers' compensation insurance on me because we clearly know only 6 people in the state are doing it. And I'm severely injured. You guys are now liable to me also. Right? So this is where it's a really big deal. Now there is a program in Wisconsin where, and I do workers' compensation insurance in Colorado. I'm not that familiar with the technicalities of workers' compensation here and what the caps and the maximum payable benefits, all of that kind of stuff is. But you guys have a uninsured fund in the state of Wisconsin that pays for people whose employer screwed up and didn't classify them properly. But now the employer is responsible to reimburse that fund. So there's a potential, again, I don't know the specifics of the maximum. In Colorado, there's a maximum payable injury benefit of $160,000. Now, you may have to pay temporary total disability, something like that, but you still have to reimburse that fund. The other kind of thing to consider is if I'm a doctor, right? I don't know how many coaches are actually doctors, but let's hypothetically talk. If I'm a doctor and I get injured on the job and my hand gets crushed because your ref stand fell and I crushed my hand and I can never perform surgery again, right? You're not only liable for my x-rays and my hospital visits, but you're now liable for the fact that I can never work in the same capacity that I did prior. And now I have future lost wages of, I don't know, maybe I make 250 grand a year, if not more, and I can never work in that capacity again. This is a really big deal, right? And it's really, really scary that a lot of you guys don't have this insurance. I have no idea what the cost is. Does anybody that actually carries workers' compensation insurance want to talk about the cost of it? Because I have no idea around here. Yes?
I just dealt with one club and they were gathering information because they found out about this law, and they said based on, it's a smaller club, they said based on their size, the first year was $800 and it's $500 every year after that. So that's just based on, and I can send that information out after the meeting, the person they contacted, but they said there's a baseline, and based on the size of their club, the lowest rate that they could get was the $800 for the first year and then $500 after that.
Yes?
It does vary greatly based on the number of coaches.
Right. This was a small club.
Yeah. So I have like 30 coaches on staff, it's about $1,600, $1,700.
Right. So, you know, unfortunately, I hate bringing this to your attention because that only means that it's at some point going to increase the cost of you doing business, which is passed on to our kids. Unfortunately, it's just the reality of the situation, and I hate that. But my interest, I do all defense work. That's all I do. I cannot stand the people that are making frivolous claims and filing frivolous lawsuits, all of that kind of stuff, which is why I do what I do. And unfortunately, my job is to cover your asses and let you know how to cover your own. So, again, I told you you guys would really like what I have to say sometimes, but this is why, but it's really important to know. Bottom line, get your workers' compensation insurance, please. All right, maybe you guys have some contacts of people that sell this kind of stuff and do this kind of work. I don't know anybody out here that does it, but at some point, like ASAP, you guys need to get this insurance. My closing advice, okay? This is bullet point number 1 is probably the thing that I have to repeat to my clients the most. And I get clients in the door all the time that say, well, I know I'm right. I know I'm good, but they're filing this lawsuit or they're threatening this, right? What you need to keep in mind all the time is that people can file lawsuits for whatever they want, right? And unfortunately, we live in a litigious society today. And I wouldn't have a job if we didn't, but every single day I'm seeing more ridiculous complaints, there are lawyers out there that are just, I see letters from the plaintiff side, which is the consumer side, that I'm just like, what? Like, there's actually a lawyer out there that would represent you in something like this, or that would even have the audacity to write a letter about this? But unfortunately, it exists. And for my profession, it doesn't really further, the love for lawyers out there. But I hear all the time, well, you're saying that I'm totally fine, so I'm just gonna stick my foot in the ground and, fluff my feathers, and because I'm totally in the right. Great, you're totally in the right. That doesn't mean that they can't file a lawsuit, right? And it doesn't mean that once they file that lawsuit, you've got to come to me and pay me $250 an hour to get you out of it. So really keep that in mind, that the important thing is that you do everything in your power to avoid pissing somebody off enough that they run and file a lawsuit, because it's going to cost you a lot of money, unfortunately. Proper documentation of everything. I can't stress this enough. If you have a conversation with a parent, right, about the contract or about payment or about anything, if it's a verbal conversation, you've got to follow up via email. Dear Mr. Smith, this email confirms our conversation we had today on August 14th, 2016, where we discussed this and you said this. We agreed to this. If this is not your understanding of the conversation, If I'm mischaracterizing our agreement, please respond and let me know. Otherwise, I'm assuming this is our agreement, we're good to go, and here's what you have to do. This is probably one of the biggest things that I see clubs screwing up all the time. Well, yeah, I had a conversation with Kaylee's dad, and he told me he would pay me by this date, but I didn't get payment. Well, Kaylee's dad's just gonna say, I didn't say that. I had no idea what we were talking about, right? So we do a lot of things because we trust people, and we do have the kids' best interests in mind, and unfortunately it comes back to bite you, and it affects the other kids when you don't get paid because somebody else doesn't stick to it and you have no proof. Please, please, please document everything, all the time. Okay. Again, put everything in writing. You guys really need to get your contracts looked at. Maybe, I mean, I don't know. I would say that if you have not had a lawyer, look at your contracts, look at your player handbook, your coach's handbook, all of that kind of stuff. At some point you need to get it done. Especially if you've invested a lot of money into your business. There are people out there like myself that I do this all the time, and I don't charge an hourly rate for it because you guys don't build in your budget lawyer fees, attorney's fees, you just don't. And so what happens is you guys wait until some issue comes up, a parent sends a letter, maybe your parents, your kids' parents are lawyers, and so they fluff their feathers all the time, right? And then all of a sudden an issue arises and you don't have the money in your budget to pay somebody, which is understandable. Proactively build this in. I offer for my clubs $500 a year. I'll look at anything you have, anything. I'm not going to charge you hourly. You don't have to pay me $250 an hour. I'll do a complete document review every single year of everything you have for $500. There are people out there that offer services like that. You guys can call me. I'll figure it out. But you need to build in proactively a way to cover your ass and not make it a reactive thing. When in doubt, cover your ass, right? This is what we should all be concerned about. And I put every single conversation that I have with somebody in writing, whether it's that follow-up email just to cover my own butt. It's really, really important. Remember how much you guys hate hindsight, right? Like, you're like, God, I should have done this if I had only known, right? That feeling sucks. And I guarantee you at some point you're going to have it with regard to some legal issue or, you know, parent that comes up and something becomes an issue. And you're going to say, if I had only done this, if I had only done that, if I had only gone to a lawyer and got this all figured out, right? I'm not pushing legal advice because I'm a lawyer. I'm pushing it because it is important. And I know it's expensive. It doesn't have to be all the time. But the cost-benefit analysis, I think if you look at how much you could potentially save in liability, is a really, really good deal. When in doubt, always consult an attorney. You guys have my card is in there. If you guys ever have an issue, not a big issue because I do, you know, have a normal job too. But you guys can call, and I'm not going to charge you to tell you to answer a quick question. All right, this is what I do. I'm not only a lawyer, but I love volleyball, and this is my passion, and I'm so blessed and so thankful to have found kind of this cross-section of where they could meet. And I really am thankful to finally be able to put my education to a good use in something that I love. So if you guys have a question, you have an issue, whatever it is, you guys can give me a call. Now I can't give you maybe Wisconsin legal advice or like represent you. Depending on the issue, maybe I can. There are ways around it. But shoot me an email. You can contact me through BJ if for whatever reason you lose my information. Please, please use me because I'm here and I won't charge you for a quick answer. Does anybody have any questions? Yes, ma'am.
I just have a couple things that I wanted to say. For those who don't have contracts or handbooks or stuff like that and are just completely overwhelmed, The Badger region did develop a sample handbook, sample coach contracts, things like that are obviously not legally binding, but give you a start as to, oh my God, what do I do now? So those are on the Badger region website. They're very general, but obviously consult an attorney, but it is a starting point for these things for you. And also, the state of Wisconsin is aware of volleyball clubs. There are circumstances going on right now that they are aware of volleyball clubs. They are going to be looking into this. And so I urge you to heed this as much as it's not fun.
Yeah, nobody ever likes when I present, unfortunately, because I always tell you that your costs are just going to increase. Yes.
I was going to ask just with respect to employees versus independent contractors. First of all, when we run tournaments, we're treating our referees as independent contractors. Do you think that we're at the ballpark with that? And what about situations where our very limited term people, such as work at a camp and they're there for a week, or someone who would be a tournament director for one day? Do you think those all fall into an employee versus independent contractor situation?
I think your tournament directors are independent contractors, right? Because yes, you're controlling certain aspects. Remember that this is not a all or nothing test. It's kind of the one that we talked about originally, not the workers' compensation insurance. You have to, I would say you have to carry workers' compensation insurance on that person that's running your tournament. But as far as the IRS type misclassification issues, they're free to work for anybody else, right? You pay them a certain way, all of that kind of stuff. I think the how much you control them, whether or not they can work for somebody else, and how integral they are to the business itself are the three most important factors. They're really not that integral. I mean, they're running a tournament, but it's not the knowledge, the specific thing that they're offering. I mean, they're really just paid to sit in a chair, right, and write the scores in. So they're not that integral to your particular business, because your business is coaching club, not running tournaments. And I think while you control them a little bit, they're free to work for other people. Refs, are you talking about from a region standpoint or for your club?
So, I mean, we run a tournament, we hire the referees through the region. And the region suggests to us that they're all independent contractors.
Refs are kind of I think they're a little bit more of a gray area. And I think USA Volleyball currently, I've talked to a lot of people over there, they're dealing with the same thing. I think while you have the right to control them, that they're free to work for anybody else that they want. They have to provide their own education, right? And it's not really from a club standpoint. Now maybe the region may be a different story, but from a club standpoint, it's not that integral to the business that you're providing. You're not paying for their training. You're not making sure that they're up to date, any of that. You're hiring somebody else that somebody has told you has the proper certifications, all that. So I think refs are a little bit more of a gray area than tournament directors, but I think you may be safe with independent contractor status from a club standpoint.
And then camp coaches.
Camp coaches, I think you're good with independent contractor status. Again, because they're free to work for anybody else that they want. It really is such a short-term thing that, you know, there are certain camps, like I just came back from Fort Lauderdale where I was there for 12 days doing Select A1 for USA Volleyball, and there's a little bit more of an argument to be made just because of every single thing that USA Volleyball controls, including what I can eat and what time I have to be in my room. But I think for, you know, 1, 2, 3, 4-day camps, that type of thing, I think you're okay. But again, I don't know necessarily the specifics. Anything else? Yeah.
How about, can you just clarify for us, because I know that there are clubs, especially the smaller clubs, that are still doing a lot of work on a volunteer basis.
Mm-hmm.
Is there anything that's different when it's a volunteer versus somebody that's getting paid?
For the IRS purposes or the workers' compensation?
Either.
So there is a provision in the Workers' Compensation Act for Wisconsin that says that if you're a volunteer, you only have to be covered by workers' compensation insurance if you receive goods or money as compensation, so t-shirts, goods, that kind of thing, right? In the amount of $10 per week. So if you're providing a shirt a week or something like that at more than $10, then you have to cover them. For IRS purposes, there's really not an issue because they're not paid. So there may be more of an issue as far as like other civil liability and that type of thing. But specifically for the W-2 versus 1099 issues and the right to control test, they're not paid, so it really doesn't implicate liability at that point.
So workers' comp probably makes sense to have them listed as a under workers' comp.
Yeah, so here's the thing about workers' comp insurance. Even if you can get away with not having it, which again, I don't think any of you can, it really is to cover you, right? And it really is important. So the idea behind workers' compensation insurance, and it's the same, at least in Wisconsin I've looked into compared to Colorado, is that it takes away tort liability for the employer. So it's the only remedy for the employee. If I get injured on the job at your club, in your gym, and you have workers' compensation insurance, I cannot sue you personally. Okay? I may be able to sue the manufacturer of the faulty ref stand that I fell off of, I don't know, but I cannot sue you personally. So it really insulates you from liability. And that's the only remedy. Now, if you don't have it, then I can sue you, right? Or I can recover from the uninsured relief fund, whatever it's called, and then you have to reimburse them. But workers' compensation insurance is always a good idea, and I think they do it based on like set group amount of employees. So like, 8 to 15 and 15 to 25 and steps like that. So if you can fit somebody into that little area, it's always a good idea. Okay, so I encourage you guys to call me if you need anything, if you have any additional questions that maybe you don't want to ask here in front of this big group. I'll be around for a couple of minutes before I head to the airport, but I appreciate it all, and I'm sorry that I gave you kind of advice that maybe you didn't want to hear, but I think it's important. So thank you guys for allowing me to be here and taking your questions.
And now to happy things up, we're going to give away 3 boxes of volleyballs. Before we take a break.
Should I stop?
Sure, Ryan's getting the
Should I
ball.
stop the?